Topic 3 on mode of commencement. So now we've decided to commence action. We have chosen which court to do it at. Next thing is there are different ways to commence proceedings. So the methods of commencement, they're also called originating processes. So remember this term. So Order 5 Rule 1 says there are two main methods of commencing proceedings. They are we call the writ of summons, or more colloquially, you will hear people refer to the writ or the originating summons, except where required otherwise by statutory provisions. So actually, there are more than two, but these two are the main ones. The other two are called a petition and a originating motion. So the first two are always preferred. The third and the fourth one can only be used if there is some specific provisions allowing it. So petitions are used for, you hear about them in divorce, unfair prejudice, so you've learned in company law, and also bankruptcy or insolvency proceedings. Those are commenced by petition. Nowadays, what remains of originating motions are usually civil appeals. So actually, there are four methods, but actually the first two are the main ones. And you'll realize in practice that the writ is used by far the most often used mode of commencement, probably about 90% of the time. Okay, so most actions are by writ. What is the writ of summons? A writ must be endorsed with either, so two things. What does endorse means? You must include in the writ one of two things. Either you have the statement of claim, so we'll come to that in a later video, but statement of claim means it is a formal statement of peace claims. It is the plaintiff setting out his case in a formal court document. If the writ has a statement of claim included with it, it is called a specifically endorsed writ. If one does not want to include an SOC, one can only include a concise statement of the nature of the claim or the relief or the remedy. So it is not a formal statement of the claim, but only a summary of peace claim. We call that a generally endorsed writ. Now, these two different options may have an effect on the time periods of the next step. If the remedy is only remedy claim is money, then one more thing must be included in the writ, a statement that defendant may make an admission in accordance with Order 13A. Okay, we'll come to this in topic 5. For an action to be commenced by writ in the DC, there is one additional requirement. That is, the writ must also contain a statement that says that the relief sought falls within the jurisdiction of the DC, specifying which section. Okay, so let's say this claim falls within section 32 of the DCO, okay, because it is within $3 million. A writ has a period of validity. That means only for the purpose of service, a writ is valid for 12 months, beginning with the date of issue. What does that mean? So, what does it mean by a writ is issued or writ is served? First, for calculate the period of validity, it begins on the date of issue. So it is not 365 days for 12 months. It is 1 day less than that. Okay, so if writ is issued on the 15th of August 2013, it expires on August 14 the next year. In practice, though, Most of the time, this difference does not matter because most writs are served the same day as issue, but not always. So what's the difference though? Issuance of a writ means the plaintiff would bring a draft writ to the court registry, so leaving blank the action number. So the court registry gives the action number written by hand and then sealed by the court sealed. From that action, the writ has been issued. And the significance of the issuance date is it stops the limitation clock. But once a writ has been issued, the plaintiff can choose not to serve it yet. So P can wait 12 months before serving it. So here service means P formally delivers the writ to the defendant. And this action has different consequence. It starts the pleadings clock. Okay? So plaintiff can just want to stop the limitation from running yet, but I don't want to go on to the next step yet. So one can wait 12 months. Even a writ can be extended though. So if 12 months is about to expire or has expired, the plaintiff can decide to issue a new writ. So there's no need to extend because limitation has not expired. P can simply issue a new writ, or one can also apply for extension of validity under Order 6 Rule 82. But there must be good reasons for the extension, and court can decide whether to exercise this discretion. There's less likely to be good reasons if the extension will expire after the underlying claim's limitation period or the application is made after limitation period. Okay? So you're more likely to get an extension if you have not passed the limitation yet. So the point here is, why have you waited so long and wait for the limitation to expire? If you have issued the writ to stop limitation, why are you not serving it? Why are you waiting longer before proceeding? So there must be some good reason, right? So these have been held to be not good reasons. So for example, here, waiting for another case to try or to be appealed, to save costs, and the mere fact that there's no prejudice on the defendant. Okay, so these are not good reasons. If you don't want your writ to expire and the limitation has expired, then just serve it. The other main mode of commencing proceedings is by OS, originating summons. The procedure is in Order 7 and Order 28. Do not confuse, though, as it is often confused, an originating summons with a summons, just because the names are similar. The OS is used, as we discuss here, as an originating process to start an action, whereas the summons, this document, is for making interlocutory applications after there has already been proceedings on foot, so already started. So we'll come to this topic afterwards. How does one choose between using a writ or the OS as the originating process? The OS procedure is appropriate where the sole or principal question at issue is construction of any written law or some other question of law. Therefore, unlikely to be any substantial dispute of fact. So you can see that the OS procedure is much simpler and quicker than the writ procedure. Writ procedure is used when the opposite of this. So where there are dispute of fact, and therefore the court would require pleadings, would require extensive witness statements, and for witnesses to come and testify, for the court to decide where the truth lies. OS is where Okay, the court is usually only asked to decide a question of law, but there isn't much dispute about what the facts are.
But then see here, unless the plaintiff intends to apply for judgment under Order 14, that is summary judgment, which we'll touch on later on, or under Order 86, summary judgment for specific performance, or maybe there's some other reason that the court considers proceedings is more appropriate to be begun by writ, then OS is not the appropriate procedure. So therefore, if the plaintiff intends to apply for summary judgment, then OS is not the appropriate method.
So again, from the previous discussion, we know the writ procedure is designed to deal with substantial dispute of facts. So that's why we have more uh, complicated procedures for pleadings, discovery, trial by oral evidence. Therefore, it is slower and more expensive. Whereas OS procedure is less complicated and moves faster because the court is only deciding questions of law. Okay? And there's usually no live witness. The evidence is just written evidence, okay, without cross-examination. Now, that's not always the case, but that's usually the case, okay? Just written evidence, no live witness, whereas here we have live witnesses. What if the wrong mode of commencement is used? We recall from Order 2, Rule 1.1 that any failure does not nullify the action. So it's still on foot. It does not mean everything is cancelled or void. The court can give directions to deal with the situation. Uh, what often happens, okay, is let's say the plaintiff has wrongfully commenced using the OS procedure where there is a dispute of fact. So what the court can do is usually is order the OS action to continue as if begun by writ, and then give directions for the filing of pleadings and witness statements. So usually the consequence is cost only.
Who can commence proceedings? Generally, anyone can do it, either in person, that means being unrepresented, or through the help of a solicitor. There are two exceptions to this rule. The first one is for a body corporate, that means for a company, in the CFI only, must sue through a solicitor except with leave of the court. That means you all learn from company law that companies don't exist and they must be represented by directors. But a director cannot just show up in court and say, here is a board resolution authorizing me to represent the company. That only works in the district court or other courts, but not the CFI. In the CFI, a company cannot be represented by a director only, but must do it through legal representation. The other exception is for a person under disability. For that, we mean a mentally incapacitated person or a minor. They must, through Order 80, either sue through somebody called a next friend, so somebody who can represent them, and this person, again, cannot act in person, but must be represented by a solicitor. And similarly, they can only defend a claim through not an ex friend, but a guardian ad litem, also through a solicitor.